Hello, thank you for joining us this afternoon from Reddy and Newman's office. We're here with our weekly update every Tuesday at 5 o'clock Central Time. This week, I have Ryan Wilk with us. He's an attorney with our office. He's one of our partners here at Reddy and Newman. He's been with us for about 10 years now, so he's got lots of experience with immigration and will be able to answer your questions as well. Topics that we want to discuss today. We have some new information coming out of the Texas Service Center based on some pending litigation that's ongoing there that really explains what's going on there and why they are taking so long to process adjustment of status applications and EADs and APs for all the people that filed last October 2020. Also got the latest check-in with Charlie through the American Immigration Lawyers Association. This is coming from the chief of the Visa Bulletin, who's retiring soon, but he gave kind of a last round of insights. And it's got some important information that we need to be aware of as we continue to watch the Visa Bulletin and see how these dates move and how EB3 and EB2 move over the coming months. Also wanted to talk about the new travel ban that's been implemented. It does impact 8 African countries, but it's just something to be aware of and keep an eye on because, you know, we don't know what is going to happen in the future with COVID. So if you've got travel plans, even if it's not to one of those countries, if it's outside the US, definitely keep an eye on that because you know these travel bans come up unexpectedly and we want to make sure people don't get stuck outside the US. And lastly, we have a little bit of an update on DACA, which is the program for undocumented immigrants who are able to receive EADs and lawfully remain in the country, and how that interplays with what we call documented dreamers. These are the lawful immigrant kids who are at risk of aging out. All right, so first up, what is going on at the Texas Service Center? So we have obtained a declaration from one of the, let's see, this is from the Associate Center Director of the Texas Service Center, who oversees the employment-based process. And everyone who watches this knows that Texas Service Center processing times for employment-based adjustment of status applications have been horrible. Everyone's wondering, why is my case taking so long? All my friends that are at the National Benefit Center are getting their EADs, getting their APs, getting their green cards, and my case is just sitting there. Why is that? Well, number one, in this declaration, the Center Director confirms that Texas Service Center is currently adjudicating about 1,300 employment-based I-485s per month. Now, we already knew last summer that USCIS, all of the different processing centers combined, were at the rate of about 7,000 to 8,000 cases per week. Texas Service Center is doing 1,300 cases per month. But here's the really important information. Texas Service Center has 91,000 pending employment-based 485s pending right now. 91,000. So if they're processing 1,300 a month, if I'm doing my math right, I know I'm an attorney, not a math person, but I think that comes out to 70 months, 70, to get through all of the I-485s, just employment-based, that the Texas Service Center has with it right now. On top of that, what's even worse, of that 91,000, 45,000 were filed before October 9th, 2020. So over half of those pending applications aren't even part of the huge chunk of applications that were filed in the end of October 2020. These were filed before October 9th, 2020. So we have 45,000 pending from before October 9th, 2020. Take that divided by 1,300 a month. That will take 34 months or almost 3 years for them to get through the cases filed before October 9th. Now, of course, a lot of those cases filed in October in EB3 have since retrogressed, so they're not necessarily going to be looking at all of those cases and spending their time on them, but that just tells you why things are so bad at the Texas Service Center and taking so long. I don't know why they're not transferring these cases out to other service centers or sending them to the field office. Let the field office adjudicate them where they have officers available for that. So that's something really to consider, especially if your EB2 priority date is becoming current and you're thinking about maybe refiling. Perhaps you would be able to get to a different service center that way, because the Texas Service Center, I just don't see things moving right now. When they're, they posted their processing times at 10 to 20 months, but it's going to take closer to 34 months just to get through the cases that were filed before October 9th, not even touching the cases, the bulk of them filed after that. Also, so as I mentioned, Charlie did give us an update through the American Immigration Lawyers Association, and he had some interesting information. Mainly thing to be aware of is normally employment-based adjustment of status, employment-based receive their green cards through adjustment of status. So USCIS uses the most of the green card numbers in the employment-based category. However, because of COVID, because people were stuck outside the US, because family members got stuck outside the US, they're seeing more demand for overseas processing than they ever have before, and they've never expected this to happen. What that means is the number that normally USCIS process for all those people with pending 485s, USCIS won't necessarily get to use all of the available numbers, because some of them will be used, more of them than normal will be used by the consulates. So that's something where EB2 might be impacted by the additional or higher level of consular processing, especially if we don't have rest of world extra numbers to spill across, because the consulates are using those extra numbers for the rest of the world. So something to keep an eye on. And also because of that additional number usage, even the rest of world category, especially for EB3, could see a cutoff date towards the end of this fiscal year, because they're seeing a lot of EB3 usage out of the consulates in China as well as India. So definitely keep an eye on that. We may expect, we saw a lot of movement, more movement than what we would have normally seen for EB2 India in December. I don't think that's going to continue in January. I think they according to this update, they moved the date in December further ahead so they could see how many upgrades from EB3 back to EB2 would materialize. And it takes several months for them to gather that data. So now they're going to kind of slow down, move it forward slowly, and then maybe in April is when we could see another big push in EB2 if they don't see too many people upgrading from EB3 to EB2. So I just wanted to give you some updates on that, things to expect in the future based on all the different factors we've got going on, because obviously we have EB3, it was in advance of EB2, now we've switched back, now we have people that might be upgrading, we have people that might be refiling, we have more and more people consular processing, which is going to leave fewer numbers available for USCIS for those filing adjustment of status. On the travel ban, so yes, this is a travel ban from 8 countries in Africa, similar to the travel bans that we've dealt with before. But the important thing is just keep an eye out, really think through whether you need to travel right now, because this ban came on very quickly and unexpectedly, and it took effect right away. So again, just like the India travel ban happened earlier, we didn't have a ton of advance notice, and we know lots of people got stuck outside the country. We don't want that to happen. So really double think through whether you should be traveling right now because of that ban. Lastly, so I mentioned DACA. So some interesting news. Number one, DACA is kind of in a weird situation right now because the original DACA from the Obama administration was blocked by a federal court because it didn't go through the full notice and comment period like normal regulations do. So right now, only renewal applications can be filed. New applications are not being accepted. The Biden administration is trying to fix that by doing a notice and comment now for DACA. And that comment period closed this week, and they received 9,300 comments about this DACA program, which is quite a bit for a regulatory process. But on top of that, we have about 50 members of Congress and senators came together and sent a letter to Department of Homeland Security asking them to expand DACA to documented dreamers so that kids that are at risk of aging out because of these delays and backlogs in the employment-based category will be able to take advantage of DACA and at least be able to get an EAD and have protection from deportation. Now that of course is just a request at this point. We would need to see if the Biden administration includes those kind of provisions when they actually issue the final regulation, now that they're kind of redoing the DACA regulations. But it's definitely good to see some action and talk happening about this. There was a really good article, I think it was in CNN this week as well, that kind of is trying to spread the news or shed light onto this whole idea of legal dreamers that are aging out and try to get some protection for them. So keep an eye on that. I think those are the main updates for today, so I think we can go to some questions.
Okay, yeah, first question that came across was related to what you just mentioned, on any legislative action, anything like that. So it seems like they're getting the ball rolling on these aging out kids, but personally, I don't think anything is going to be happening in the next year, at least. I think there's some more immigration concerns on top of all the other concerns that the administration has. So some movement, as Emily just mentioned, that had just come across as we were walking over. So that is new news. And so a few questions that have come across. One that popped out to me immediately was, so someone has a current priority date, maybe in both EB2 and EB3. They've done a downgrade, EB2 to EB3 last year. And the question is now, with the dates moving as they have, should you refile, file another 485 as EB2? And the question was, does that reset your position in the queue? Or should that person go ahead and refile, or they say interfile for EB2? So no, I'll take it kind of two ways. One, if you file a second 485, say you did one in EB3 and this one you're doing in EB2, that will not reset your position in the queue. In fact, it's going to give you two queues to stand in. One you'll be sitting in the EB2 queue, the other the EB3. My take on interfilings is there are benefits, but if you do have the opportunity to file a second 485, that's the position I would prefer. There's pros and cons to each aspect. For me, I think I would be more comfortable in doing it filing a second 485 rather than doing an interfiling. And so another question that popped up was, what happens if I'm jobless during my GC interview day? It's likely that your green card would be denied if you don't have a job offer in hand. Now, you are able to walk into that interview with a 485J from Company B, Company C, Company D, as long as your 485 has been pending for at least 180 days. So if you have no job offer and that interview notice comes, as quickly as you can, find an employer who'd be willing to sign that supplement J for you, and you shouldn't have any issues come that interview day.
Another question, this is from Simbu from YouTube. I would like to know the best approach to get my wife's H480 automatic extension. My H1 expires July 2022. My employer will file the extension in January 22. Is there a way I can get my wife's EAD? So part of this really depends on what's going on with the consulates, because we do have difficulty with people being able to get the visa interview or even the Dropbox if they qualify for that. So let's assume that you can get an H4 visa appointment or are eligible for the Dropbox. One way to get the auto extension would be to file the H1B extension as early as possible in premium processing, get it approved, have your wife exit, apply for the H4 visa at the consulate based on your H1B approval, assuming she gets the visa stamp, comes back in, and then files for the EAD renewal before her current EAD expires. In that way, she has an I-94 for H4 status that's extended beyond the current EAD validity period, and she'll have a receipt notice for the EAD renewal showing it was filed before the current EAD expired. Those will allow her to get the 180-day auto extension. Right now it's tough because we don't know consular processing, how that's going to work, if the timing will work out. Otherwise, it would be filing the H1 and H4 and EAD together as quickly as possible and just hoping that the H4 gets processed first. As soon as that's approved, then the auto extension kicks in because the EAD would have already been filed before the current EAD expires. But yeah, the auto extension is helpful in some limited situations. It's definitely not the end goal with getting processing times to be better for the H4 EADs, but it is something that, as kind of a backup plan, perhaps travel can help.
We have a question from Cy. Yesterday, his case status online, this is related to a 485. His case status was changed to new card is being produced, and today it changed to cases approved. There were no updates on his EAD or advanced parole. So his question is this good news? Yeah, that's great news. Your green card has been approved. You don't state here in your prompt, but it seems USCIS has waived the interview. And so you should be expecting that green card in the mail, hopefully within the next week. So congratulations to you on being admitted as a lawful permanent resident.
Yes, and Rod's from Facebook says, when is the AC21 rule going to kick in if we do an interfile from EB3 to EB2? Now, I don't think there's any regulation or guidance from USCIS that confirms this, but the American Immigration Lawyers Association did put out a practice pointer where they recommended that you wait 180 days from the time you do the interfile before you take advantage of AC21 to change jobs. That does make the most sense. That's the safest way to proceed, but there is a gray area. There's not really any guidance from USCIS on that. This idea of interfiling or second 485 filings, it doesn't come up a lot, so much so that they have to put out guidance on it. So we kind of have to make the law how we want it until then.
And then to that point, you say 180 days after you do the interfiling to do the 485J. How would you know when they've accepted that interfiling?
Yeah, you don't know. That's the difficulty. Would you go by the date it's delivered to USCIS? At least you have that documentation in case the question arises at an interview. But that is one of the difficulties with the interfile, is you just don't know when it's actually accepted.
And the next question from YouTube came from Ram Raju. He asked, can you work part-time on your 485 EAD until your green card is approved? The answer to that is yes. The EAD, even though it's tied with a green card, gives you the right. I always say you can work at McDonald's or you can be the CEO of Tesla, and you can do everything in between. Truth to tell, you could even be unemployed. Now, when you walk into that interview, you need to be prepared to do whatever the job is that's on that PERM. Or if you're doing an AC21 Supplement J, the 485 Supplement J, it needs to be a same or similar job to that PERM job. So can you do part-time work with your EAD? Absolutely. But come that stage when the green card is to be produced, you need to be ready to enter into that full-time occupation.
Anoop from YouTube asks if there's any update on H4 EAD premium processing. Currently, there is no update on that. We are basically in the same boat we've been in, where we know it's on the regulatory agenda, but no steps have been taken to actually publish a proposed regulation to implement that. So it could be some more time.
Here we have a question, and I get this quite a bit. What's the timeline for receipts on 485s out of the Texas PO box? You can measure that in moon cycles, it seems like right now. I would say right now it's about a month to 6 weeks, unfortunately, just for that simple receipt notice. It doesn't seem like they're cashing the check as quickly as they used to. Usually you'd give it, and within a day or two, they might cash it. You could see that endorsement on the back, and that would give you, one, the receipt number, and two, a little indication that USCIS has been doing something with your case. Right now, check the tracking, and other than that, we're just hoping that they're not outright rejecting it for some silly reason. But right now, I would expect 4 to 6 weeks for those receipt notices.
Rakesh from YouTube says, my previous employer filed the adjustment of status based on the EB2 I-140 as future employment. When I receive the EAD, do I need to go back to my previous employer? The requirement to work for the employer that sponsored you, again, it's future employment, meaning that's the job you will take, that you intend to take when you actually receive your green card. So just because you've received your EAD, it doesn't mean that you have to go to work for that employer. It's expected when you get your green card is when you will go to work for that employer. But AC21 does allow you to change your intention and move to a different employer if your 485 has been pending for 180 days and your I-140 is approved and the job offer is similar to what you were sponsored for. So it's entirely possible that you never go to work for that company if your circumstances and intentions change after you filed that 485.
Ashutosh from YouTube asks, he downgraded from EB2 to EB3. It seems like his wife or the family got EADs. It seems like the family, he was on H1B, she was on H4. She took the EAD and she switched jobs. His question is, if the EB2 becomes current, can he refile an EB2? The answer to that is yes, but we have to think of it a little bit deeper than that. So when your wife used on H4, when she used the EAD, that knocked her out of status. Now she's fine to be in the country. She has the pending 485. She has the EAD, so she's fine to work. If she wants to join your next 485 filing, so say that EB2 comes current and you want to file the 485, she would need to get back into H4 status or enter her own H1B status or have some other non-immigrant status that would allow her to file the 485. So right now, she would not be able to file the 485. She needs to get back in status. And you close your question, would she lose the job if she comes back in H4? No, she just needs to get back in H4 so that she can file the 485. If the EAD is still valid, she can likely still stay in. The issue is getting in a legal status, filing the second 485, and after that, you're sort of back to where we are now. She can use that EAD and she's fine.
Manoj from YouTube has an H1B extension pending with the California Service Center and says some are still waiting back from April. Why is it taking so long for H1B extensions? So we do see the processing times for H1Bs kind of come and go, increase and decrease over time. So it's not unusual. I will say that one of the reasons why extensions can take longer is they're kind of lower on the priority list for USCIS, because when you file an extension with the same employer, you get an automatic extension of your employment authorization for 240 days beyond when your current H1B expires. So there's not a big rush for USCIS to hurry up and process extensions, because they know that you can keep working and you can stay in the US while that extension is pending. So not entirely unusual.
So our friend Manoj from YouTube asks a similar question. Instead of the EAD, the question is framed around the advanced parole. So they filed a 485 with an EB3 downgrade. He was the primary, his wife or his spouse was the derivative. The spouse traveled and wants to come back on advanced parole. Now, if she comes back on advanced parole, she's just being admitted on the advanced parole. She has no status, no legal status that would enable her to file a second 485. You, as the primary, can keep working on H1B, no problems. The question comes, can we file the second 485, this time under EB2? The same scenario applies. If she comes back in on advanced parole, she would probably need to go back out and come back in on H4 so that you can file the case. That previous EAD, that previous advanced parole will likely stay active and approved for you to use later, but to file that second 485, you need to make sure that you're in here in the country, for her on H4, for you on H1B, so that you guys can file the 485. The key is being in a legal status at the time you're filing the 485.
Yeah, a similar question to that. Ashutosh downgraded from EB2 to EB3, and since that time, his wife, who is on H4, used that EAD to start working. Ashutosh is still maintaining his H1B status, so if EB2 becomes current, can I refile an EB2? Yes, you can, because you have continued to maintain your H1B status, but before your wife can, she would need to exit, come back in on H4 to regain her H4 status, and then she can file. It is somewhat easier for an H4 to regain status after they've used the GCEAD or the AP compared to an H1B, because the H1B requires the employer and a petition to be filed and approved and all of that. For an H4, they can get the visa stamp, or they might even qualify for automatic revalidation if the I-94 of the H4 has not expired. You can go out to Canada or Mexico for a short trip without going for stamping and come right back using an expired visa stamp and a valid I-797 with an I-94 to regain H4 status and then file the 485.
Srini asks, it's been 10 weeks since they applied their 485 concurrent at the Texas Service Center. He asks, when can I expect my biometrics, and also when can I expect my EAD and advanced parole? For the biometrics, They're not long coming. They seem for me a little random on why one person versus the other gets a little bit sooner or a little bit later, but they don't seem to be taking terribly long. I would assume 6 to 8 weeks is reasonable to wait for the biometrics, but then they're going to take it, and unfortunately that case is probably going to sit for some time. To get to the advanced parole and EAD, hate to be the bearer of bad news, but it's at least going to take a year. Would you agree, Emily? I mean, we were filing cases in October of 2020 and have seen, I would say, a literal handful of EAD and AP approvals. So if you're filing, 2 months ago, unfortunately, you're probably looking for 10, 14 months into the future to see that approval.
Jay from YouTube wants to know what to do if the address location has a typo on the LCA for an H1B. It's just a single number and that need to go for stamping. I would say the majority of typos are not going to negatively impact the stamping where you can clearly see that it's a typo. I would say now maybe if it's the first digit of the zip code to where it looks like it's a completely different state or something like that, maybe it could be an issue. But if it's like the street address or an apartment number and that's off by a digit, that LCA is valid basically for the entire county. So I wouldn't be too concerned about that with going for stamping.
JJ Investor from YouTube states he has an EB2 I-140 approval with a priority date May 2012 from a prior employer. He wants to go back to that employer to file the 485, but he has a question. They've been showing negative taxes for a few years. He asks, will that be a problem for the 485 approval? It may be, but I don't think it should be. Now, there's nothing in the regulations or the law that says you have to have positive tax returns. What the law speaks to is the company's ability to pay your PERM wage. And so there's a number of ways that can be shown. One way is your W-2s. If you were a past employee, maybe you don't have those for the last few years. So we would need to look at the tax returns. USCIS would look at the company's net income. Independently, they would look at the company's net assets. If maybe those aren't in a position to help us. There's a number of things that you can do to overcome this. If the company is big enough, they can write a letter from their CFO stating, hey, we have that ability to pay, and USCIS will typically take them at their word. If it's a publicly traded company, someone who's filing with the SEC, those annual reports will typically carry the day for us. Other avenues are audited financial statements. Often those numbers, the accounting practices for auditors are different than tax accounting, so the numbers may reflect differently in those audited financial statements. All these things tend to stand on equal footing with USCIS, but they will upfront want to see those tax returns. So will it be an issue? I can't say yes or no. It may not be. It will come down to what that company looks like. So I would consult with that company, consult with that attorney to see if their numbers aren't going to be something that can support your green card filing.
Prashanti is on H1 and wants to know, if I take a break from work for 3 months and then join back, will I be out of status? Can I do that? I think it really depends on the reason for the break. Most commonly maternity leave or some sort of medical leave, that is generally fine for not working and still being considered to be an H1B status, as long as your employer agrees to it and it's part of their normal policy to let US workers to take a break like that. Now, if you're just taking a break to take a break, that would put you out of status. When you're in the US in H1B status, you need to be working unless you have some sort of, usually a medical leave for taking a break.
Here's a question I'd actually like your thought on, Emily. Anamika Thakur states he or she has a briefcase full of documents with so many H1B extensions over the years. What documents are absolutely necessary to keep from those past approvals? Would you consider it just the I-797 approvals? Would you want to keep those LCAs?
I have never needed to submit LCAs from the employee standpoint, like when you're filing your 485. So I really just the I-797 approvals and then the passport, old passports, visa stamp.
Those things showing that you were lawfully admitted, that you were maintaining the status. If you maybe drop the status, things that show you got back in the status, etc., when you're filing that 485, or maybe when you're filing, any other adjustment or anything like that.
Yeah, I think W-2s are probably more important than LCAs or anything like that.
Yeah, that's true. Yeah. I see some questions about dates moving forward over the next year. It seems like a lot of folks are asking about the EB3. My view, and this is just my view, I don't see much movement on the EB3. I think there's going to be some small lurches forward on the EB2 side. But with the numbers Emily said, I think USCIS will put up sort of an impromptu gate to keep the waves from crashing in. I think they had a big wave crash October 2020. They're still trying to recover from. So I'd love to be wrong, but I don't see much movement in the EB3 dates this year.
Narayan wants to know if there's any provision in the BBB Act for aging out kids. For the BBB, that's the Build Back Better, that's the reconciliation bill. The House did pass their version of the bill that has immigration provisions. There's no provision specifically for aging out kids in the House version of the bill. But that said, their provisions for parole and employment authorization for undocumented would be someone else who is documented, who meets those requirements, entered the U.S. by that time period, would be eligible. There's no restriction saying you can't use this provision if you're legally in the U.S. So some people could potentially benefit from that, but we still have to get through the parliamentarian and the Senate and have the same provisions on the Senate side, which we're waiting to see if that will happen.
Jolly Mail 121 from YouTube asked a question, and I have to sort of read through, and I'll give my best answer, but he seems like he moved companies after an I-140 was approved for 6 months. It seems like his new company states he's not eligible for the EB1. Can he go back to his old company? Will that EB1 I-140 be valid? With what you've told me here, I would say that yes, that EB1 I-140 approval will remain valid. If that company went out and withdrew it, it's unlikely that it would be valid for 485 purposes, but you could use that I-140 approval for any H1B extensions that you might need. Even if they withdrew it after the 180 days, you can still use it for the H1B extensions, maybe H4 EADs. And of course, you keep the priority date. But say maybe your priority date is current and you're wanting to file the 485, say that company withdrew the I-140, it's likely that they would need to refile it, and they would likely get the approval, but that's the course of action I would take. If they withdrew it, refile it, everything should be fine in the end.
David from YouTube has an approved I-140 for more than 2 years, but moved to a new employer and wants to know if this immigration bill passes, can the current employer file for adjustment of status, or do I have to go back to the old employer? So the House provision that allows you to file the adjustment of status if your priority date is 2 years old doesn't change any of the other requirements to file for adjustment of status. So you still need the employer that filed the labor, filed the I-140, you need their support to actually file the 485 because they have to sign that supplement J. So it doesn't eliminate any of the requirements that you still have to have a sponsor that qualifies, one that filed the labor in the I-140. Do you have to go back to the previous employer? You don't have to go back to them for filing the 485 because again, the 485 is the idea that that's the job that you will move into when you get your green card. You don't have to be in that job right now, but the employer may require you to join them before they'll be willing to support the 485 process.
Rashil on YouTube asks, they applied a 485 and EB1 6 months back. They filed an EB2 NIW I-140 that's pending. They ask, does the pending EB2 NIW I-140 cause any delays to the EB1A 485 processing? The answer to that is no. You can think of them as completely separate and independent. USCIS will look at the EB1 and that green card through that necessary and proper lens. Within that lens, any I-140s that you filed elsewhere won't come into play. Now, I don't think you have any worry about this, but if there is fraud or misrepresentation on one or the other of those cases, then you may have some impact. But other than that, just filing a different I-140 from a different company in a different category, that will have no impacts.
Namita has an H4 and EAD extension processing at the Texas Service Center. And the current H4 and EAD expired November 12th, and she wants to know if she can continue to work with the receipts because she filed before the expiration. Unfortunately, no. That automatic extension, although you filed the EAD before it expires, it only works if your H4 extension has already been approved or you have traveled and come back with H4 status that already extends beyond the validity of your current EAD. So unfortunately, no automatic extension. In that situation, you'll need that H4 to be approved first.
Another question from YouTube, Saya asks, is there any option to reach out to USCIS regarding the ETA at a 485 receipt? Unfortunately, there aren't any avenues for that. Now, for me, it's unfortunately that waiting game, 4 to 6 weeks. If it's getting a little bit longer than that, then maybe you can try calling USCIS customer service, but you and I are going to have the same information. Hey, I sent a case, this is the FedEx tracking number, and here's maybe the check that I sent with it. From there, they might not be able to find anything. So that being considered, it is a patience game. God forbid USCIS commits any errors on their end and rejects the case improperly. But right now it is a waiting game. You should be seeing it in, I think, 4 to 6 weeks, 8 weeks on the longest.
Yeah, and there is, for those that are filed at the lockbox, which usually these 485s are, when it's a standalone 485, there's an email address for Lockbox Support. You can send an email. They take a really long time to respond back, like at least 30 days. So by the time you would get a response from them, you'd probably have the receipts anyways, assuming everything's fine. It's kind of a mess the way all that's happening right now. Relaxme wants to know, how is USCIS processing 485s? Is it based on the received date or the priority date, especially where EB3 retrogresses? So USCIS claims that they follow first in, first out. So it's based on the received date, but if the final action date is not current, they're not going to be fully adjudicating that application because they can't request a visa number to approve the application. So when they have sufficient staff, they often would pre-adjudicate 485s when the priority date is not current. But I think in the current environment, when they have so many applications where the date is current, they should be going mainly first in, first out by service center. It's not nationwide, so each service center does have that different processing time.
Naveen asks a question about an issue that I thought was slowly trickling away, but seems like he's an unfortunate guy who's found it. It looks like USCIS improperly rejected the 485, stating that the priority date wasn't current when the 485 was filed. By the facts that he's given me or that they've given me, it seems like, yeah, the priority date was current under that category at the time that they filed. So you can always resubmit that 485. It's happened for us. You point out, this was the filing date. Maybe you have the FedEx tracking receipt. You present that visa bulletin and make the argument, so to speak, that the case was properly filed and the rejection was improper from USCIS. They'll likely give you that rejection notice, so you can maybe put that back in their face to show them that it was improperly rejected. What I say, it's better to wait for the EB2 to become current. Why not fight and throw the punch? The worst that happens is you get another rejection. The best that happens is that they accept the case and they continue forward with your 485.
Leah from Facebook currently has AOS pending as a dependent and wants to know, can my employer file an H1B petition if I've used my GC EAD? I have my H4 and H4 EAD in process, but haven't heard back yet. So they can file an H1B petition, but to request the change of status to where you don't have to leave the country to get into H1B status, you have to be in H4 status. So if you've used that GC EAD, you need to get back to H4 status first and then file a change of status from H4 to H1. Otherwise, your company can just file the H1B, request consular processing. Once it's approved, you exit, apply for the H1B visa stamp, and then come back in. You'll get a new I-94 at that point, putting you in H1B status.
The next is a question I think I handle a few times a day. And so someone did a downgrade in October of 2020 from EB2 to EB3. The EAD has even been approved, but the I-140 is still pending. They ask, can I go for premium processing? The answer to that is yes and maybe no. So can you go forward with premium processing? You can file it. And the worst that happens is that they send you back a rejection for the premium processing, say we can't handle it. And I won't get too technical, but essentially the reason will be that the PERM is too old. And so what do we do as an office? We just keep sending it back and knocking on the door until they finally accept. I see about a 20% rejection rate. And so, 4 out of 5 people sending that premium processing, if it's not the first bite or the second bite of the apple, we are seeing them accept it. I think if I went back through my filing cabinet, I might have 10 or 15 rejections that we're still trying to get them to accept. But over the last year, it seems like I said, 85% acceptance rate. So it's not going to hurt you to try.
Ashish wants to know, what is the best course of action for my daughter who turns 21 in April? Should I move her to the green card EAD if it gets approved? Primary applicant filed an EB3 downgrade. That I-140 is approved. EAD and AP are approved. So the main thing is her age locked in yet under the Child Status Protection Act? For those that are in EB3, you need the I-140 approval and the final action date had to be current before their age is locked in. So for a lot of people, when EB3 retrogressed, they didn't have their I-140 approved yet. Their age did not get locked in. So I'm assuming that your daughter's age is maybe not locked in yet, which means that if EB3 final action date for you does not become current before she turns 21, and you can add in the amount of time that EB3 I-140 downgrade was pending, but if her age doesn't get locked in by then, even though she was able to file the 485, she won't be able to get the 485 approved. So if she uses that green card EAD, it's going to put her out of her non-immigrant status. And when her green card ultimately gets denied, she's completely out of status. She has to leave the country. There's no way to get back into another status. So for her to use that GC EAD is not a good choice. She needs to look into filing a change of status to F1, assuming that she's continued to maintain her H4 or L2 status after the filing of the 485, and not use that GC EAD because she needs to have that F1 status to fall back on when her 485 ultimately gets denied.
This is another age out question. They have both an EB2 and an EB3. The I-140 in each category was pending for a different time. Which period is to be used for calculating the age? So if you're filing the EB2 485, use the calculation pending time for that EB2 I-140. The same goes for the EB3 485. Use however long that was pending for the EB3 I-140 approval. Would you agree on that, Emily?
Yeah,
okay.
Absolutely. Yep. Let's see. Barath has the $1 million question. What are the odds of getting the legal immigration provisions passed in the Senate? We just really can't predict. Generally, it's difficult to get immigration reform passed. Obviously, we've been talking about immigration reform since the Gang of Eight and the Comprehensive Bill and John McCain and all of that, and even before that. This has been a very long process. What we have right now is a unique opportunity to pass some kind of reform because the reconciliation gets around the filibuster. We only need a simple majority. So our first hurdle is getting past the parliamentarian or making the Senate ignore the parliamentarian who's not an elected official and move forward anyways. Then it's what does the Senate actually put into the bill? Is it the same as the House? And if it's different, can they come to an agreement between the House and the Senate to pass a final bill? That's where the sticking point often happens. We saw that with the Fairness for High Skilled Workers Act last year, where the Senate finally passed it at the last minute, but it was different from what the House had passed earlier. And then by the time they tried to conference to come up with a solution, the year ended, the congressional year ended, and they didn't pass it. So we are at risk of that, especially where next year is an election year. Things tend to stop in terms of getting any legislation passed. So really it needs to happen in December if it's going to happen.
Srini asks, my work location on the PERM is no longer valid because the company relocated within the same city. And for us, that's actually a really good thing, within the same city. Does this impact my green card petition in any way? It shouldn't. As long as the job opportunity remains what the government calls the same MSA, the same metropolitan statistical area, you should be fine. So even if they move maybe within the same county, depending on where you're at in the country, maybe a couple counties around that, should be fine. If they're in the same city, you shouldn't have any worries.
Bardwaj has an approved EAD AP through an EB3 downgrade, but his wife hasn't received her EAD and AP yet. He has a job offer. What should my next steps be? So it kind of depends on a few things. So yes, you have your EADs, and assuming your 485 has been pending for 180 days, you could use that EAD to move to a new employer, take your green card process with you, as long as that new job is similar to the one you were sponsored for through AC21. The new employer submits the supplement J. However, if your wife currently is an H4 and is using the H4 EAD because you're on H1 and you use your EAD to move to that new job, she can't use the H4 EAD because she's no longer in H4 status, because you're no longer in H1 status. And if she hasn't received the new EAD yet from the green card process, she has to stop working. So that's one of the major things to consider, is how will it impact her if she's currently working and then not able to because she falls out of H4 status. Also keep in mind, if you do want to move back into EB2, once you've used your EAD, the only way for you to do that is interfile. You don't have the option of filing a second 485 because you're no longer in your non-immigrant status.
You could always, if it's available to you, re-enter on H1B to file that second case.
Mm-hmm. Yep.
So we're asked by Ram on YouTube, the I-140 has been approved, the 485 has been pending for at least 6 months. He's looking to do a 485J job offer portability to a new employer. That employer says that they're not going to file the 485J until an RFE starts, or until an RFE is issued. They're not going to do it at the start of employment. Is it okay to move to employer B? That last question, I want to answer it in a specific way, but to your question, or to their point about not filing the 485J until an RFE comes, that's pretty normal, I would say. There's no immediate need for you to file that 485J, and an argument could even be made that you wouldn't hurt yourself by filing it too early, but you might limit your opportunities or maybe put too many irons in the fire, so to speak. So for me, my idea is this. The Biden administration is tending to move away from the employment-based interviews like every president before Donald Trump. And so there's a very real opportunity that you wake up in the morning with an email, hey, your green card is going to be produced in about 7 to 10 days from there. You have the green card. You never have to worry about the 485 supplement J. The other side of the coin is, if the interview notice comes, at the time you're ready to walk into that interview, submit the 485 either in the mail, or you can walk right into that officer's desk and give the 485 to them. I haven't seen any issues with that. So to answer your question, is it okay to move to employer B? It's a derivative question. Do you have work authorization immediately with employer B? Maybe you need to do an H1B transfer into this company. If you've got the EAD, go work for them tomorrow, no problems, no questions asked. So have to ask yourself that, do I have the immediate work authorization, but is it okay to move to employer B? I say absolutely.
Sarah Bonin is with a new employer, and they've started the green card process and plans to port the old priority date, and wants to know, what is the current PERM labor certification processing time? So assuming that nothing has been done yet, and assuming that your employer is going to wait for the prevailing wage to come through before they start the recruitment step, it can take about 18 months to get through that whole process, because the prevailing wage still taking 5 to 7 months. Once that is received, then they start recruitment. It can take up to 6 more months for the recruitment to be done. That's 1 year before you can even file the PERM. Once it's filed, it's taking another 5 months to process. That's kind of the long end, because they may shorten the recruitment period depending on how quickly they do all of the advertising steps. But yeah, I would plan on 18 months.
Let's see. I think I was going to pick the question that you just answered, Emily. Ravenclaw asks, how can I convince the employer's lawyer that refiling is okay? Is there any official notice from USCIS, ALA on how 2 AOS applications are handled? So there are, there's a few regulations out there that are pretty clear that refiling is fine. If you're refiling an I-140, there's a very clear rule that states more or less, as long as you filed a single I-140 during the validity period of the PERM, that PERM remains indefinitely valid. So you can use that today, you could use it 10, 15 years from now, no problems there. In terms of filing multiple, maybe 485s, as long as you're in a legal status when you're filing that 485, there's no problems. The government may eventually come to you at the point of approving the case and make you pick one, but having more irons in the fire isn't going to hurt you. If anything, it's just buying one more lottery ticket, knowing that the lottery ticket's going to be picked, and it's just going to get you that green card that much faster.
Senthil wants to know, did USCIS give any process for interfiling from EB3 to EB2, or will they provide any guidance soon? No, they don't have a process for it, and I don't expect them to provide a formal process for it. This interfiling has been something that is available for decades. There are very old meeting minutes between the American Immigration Lawyers Association and USCIS operations. I think it's over a decade old, that talks about this idea of interfiling and that it can be done, but it's very clear that there is no formal process for it, and I don't see them creating one for that. It's a limited situation that doesn't happen very often to a lot of people. Generally, in the grand scheme of all the different types of applications and filings that USCIS receives, so I wouldn't expect them to do anything with that.
Prem asks on Facebook, planning to move from employer A to employer B. It seems like they have an I-140 approved with company A and a priority date September 2013. If the date becomes current, they ask, can they apply for the 485 using the old I-140 with company A, or do they need to wait and get a new I-140 with company B? You can file the 485, but company A will need to sign a 485J for you. So they've already done the I-140 for you. They need to sort of give their consent to carry forward your 485 by filing a 485J. So can you file a 485 with company A? Yes, but it's not as easy as that. You can't just take the I-140 and go forward. They will need to sign their own 485J. It's like doing an I-140 without all the headaches of maybe the PERM. It's a back-end deal. The I-140 has already been approved. The government wants to see this 485J just to make sure that the job offer is still open. You wouldn't need to go back to company B to get a new I-140 done. You may need to do so if company A isn't willing to sign that supplement J. The wall will be put up for you on that 485. You would need to get a new I-140 done with company B or company C. You'll always keep the September 2013 priority date, but as long as company A is willing to sign that 485J for you, you should be able to sign or to file that 485 as soon as your priority date comes current.
Suhas has an EB3 pending and refiled an EB2, received those receipt notices from the National Benefit Center, also has the EB3 Biometrics, and wants to know, will USCIS use those EB3 Biometrics for the EB2 case? And is there any risk of 485 transfer to the Texas Service Center because of the pending EB3? USCIS may use the biometrics from the first filing in the second filing. They also very likely will not, because they just can't seem to get their act together on these things. And yes, there is a risk of transferring the case that's pending at the National Benefit Center, the second filed case, to the Texas Service Center to have them adjudicated together. Is that going to happen 100% of the time, even 50% of the time? I wouldn't say that, but it does happen in these situations where there are multiple filings done. There is some risk of that.
David asks a question about an impact of withdrawing an I-140 before it's been approved. Now, they state the employer messed up on the job description in the PERM. They received an RFE during the I-140 stage. They couldn't get the evidence to overcome maybe the issue in the RFE, so they withdrew the I-140. He asks, what's the impact? Now, I haven't seen this PERM, so I don't know what the issue with that PERM was, but generally, the issue that you've come up against shouldn't have any impact on you in terms of impacting maybe your H1Bs or any of your non-immigrant visas. If you have any previously approved I-140s, won't likely impact them. Any future I-140s that you're filing will not likely impact those. The immediate impact is that you might have lost the ability to use this PERM if we can't use it to carry forward an I-140. Whatever the issue may be, that's likely the biggest impact. So what do? We go back to square one, we get a new PERM done. As long as you're maybe not stating something on PERM 1 that is black and white different than PERM 2, you're not going to have any issues. If there's maybe some issue where it's language that's used, you're not likely going to have any issue. Whereas if you're stating, I did A, B, and C with job 1, and you're doing B, C, D with job, the same job on different PERMs, USCIS will likely call you out for those discrepancies.
Krishna wants to know, if I change my employer immediately after the I-140 approval, but the employer does not withdraw the petition, can I use that I-140 for future H1B extensions? Yes, you can. Although you left the employer within 180 days of I-140 approval, it's the withdrawal of the I-140 approval within 180 days that restricts your ability to use that I-140 to get continued H1 extension. So if they don't withdraw it, assuming they also don't go out of business, then you can use that I-140 anyways.
Neil on Facebook asks, do you need to have the I-140 approved before you refile a 485 and EB2 if you had downgraded from EB2 to EB3 earlier? Now, there is a difference between downgrading an I-140 and amending an I-140, so let's go forward with saying that it was downgraded. If you downgraded the I-140, you don't need to wait for the I-140 to be approved to file your 485. You can always file a 485 with a pending I-140. As long as the priority date for that I-140 is current, USCIS should have no issues taking that 485 from you.
Vincent wants to know, will H1B holders be eligible to apply for the parole under the proposed reconciliation bill, even if they had frequent trips outside the U.S.? You should be, assuming that you meet the timing for when you entered the U.S. and meet all of those requirements. This particular bill doesn't require continued physical presence in the U.S. It just requires continuous residence. So if you take trips outside the U.S. but you maintain your residence in the U.S. based on your immigration status, you could possibly apply for that.
We're asked on YouTube, which option is safer to switch to a new employer, using the EAD or using AC21? You can always move to that new employer with the EAD. You can go work for anybody you'd like to on the EAD. I'm assuming your AC21 part of that question comes down to the Supplement J. I said a few moments ago, there's no immediate requirement that you file a Supplement J, but you need to walk into that interview or be ready to walk into that interview with a Supplement J from the company through which you want to work for on that green card. Yeah, that's what you need to take care of.
All right, well, I think we are about out of time for today. Thank you so much for joining us this week. We'll be back again next Tuesday at 5 o'clock Central Time. Join us on YouTube or Facebook, and we're happy to answer your questions. We'll see you again next week.
Thanks.